Hello?
Hello.
Hey, Mr. Smith?
Mr. East.
Yes, sir.
All right, thank you. This is cause number CR20244, State versus Adrian Ladon East. And Mr. East is set for pretrial today. Go ahead, Mr. Schmidt.
That's correct, Judge. We've received the discovery on Mr. East's case. We have no contested pretrial today. It has to be set for that January 12th docket call.
All right, court will set Mr. East for docket call on January 12th. Mr. East, where do you live?
Leesville, Louisiana.
All right, Mr. East, I'm going to order you to report to the pretrial supervision release office on or before Wednesday of next week. That will be December 16th, and you will need to sign conditions of pretrial release. Mr. Schmidt can give you more information about that, okay? So
yes,
on or before Wednesday of next week, the office will be closed tomorrow. So either Monday or Tuesday before 4:30 or Wednesday before 4:30. You understand?
Yes, sir.
All right. Mr. Schmidt can give you more information if you need it.
And I'll talk to Mr. East after docket today, Judge.
All right. Mr. East, you're due back, you're ordered back on January 12th, and your failure to appear on that day will result in the court issuing a warrant for your arrest. So this will be the only notice you receive from the court. Do you understand?
Yes, sir.
All right. You're free to go.
Thank you.
That's all I have, Judge. Be excused.
Yes, sir. Thank you.
All right, I'm gonna get my shoes back on.
Having some technical difficulties. Dave, did you get the setting on Miss Paula Glass, Mr. Manning's client?
No, Your Honor. We didn't hear anything after Mr. East signed off.
Okay. January 12th for docket call. No contested pretrial motions set for January 12th. Did you get Mr. Schmidt's January 12th for docket call on all of his cases? No contested pretrial motions.
No, Your Honor.
Okay. So Adrian East, Jacqueline Jacobs, and Douglas Mercer all set for January 12th for docket call.
Got it.
Counsel in the courtroom, Mr. Warner, are you ready?
I am, Judge. I think they're both under Mike's name.
Are they present in the courtroom?
Both of them are, Judge.
Mr. Hankins, Quincy Lamar Hankins, CR 20121. All right, Mr. Hankins is set for pretrial today. Mr. Warner, go ahead.
Yes, Your Honor. Mr. Head has filed a motion to suppress in this case, but rather than sit on the contested docket, I think he'd like some time to talk about the motion with the state in lieu of having a hearing immediately. And so if we could set this for pretrial again, I think that would give him time to talk to the state and see if they actually need to have a hearing.
I think I would prefer that we just go ahead and set it for contested hearing. That way, if the discussions are not fruitful, then we're already set. We don't lose time.
Yes, Your Honor.
But what we'll do is we'll set it on January 28th. So that should give Mr. Head some time to speak with the state. And if there's no request at that time, we can always appear on the 28th and make that announcement.
Yes, Your Honor. Thank you.
Yes, we'll see you back on the 28th of January, 9 a.m. Holly Mormon. She's present in the courtroom as well, Judge. This is cause number CR 16139, State versus Holly Elise Mormon, and this is set for hearing on her motion to adjudicate today.
Yes, Your Honor. This is the first setting. We were retained recently, and so we're asking for some more time so we can talk to the state about an offer.
Any objection from the state?
No, Your
No,
Honor.
Your Honor.
All right, we will reset Ms. Mormon then for January 12th. Ms. Mormon, while Mr. Weiner is filling out the notice of appearance for you to sign, I want to remind you that you're still on community supervision. You're still required to report and comply with all your conditions. Do you understand?
Yes, sir.
She signed, Judge.
Yes, we'll see you back on January 12th. Yes, thank you, Ms. Weiner.
Merry Christmas.
Ms. Weiner, Mr. Gimbel, Mr. Adams, anyone got a client in the courtroom and ready? Who was here first this morning? Mr. Gimbel, come on up. Who are you ready on?
Miss Jones, Jasmine Jones.
CR 2256, Ms. Jones. Show we're set for pretrial today.
Yes, we are, Your Honor.
Any contested pretrial motions?
No, Your Honor. Miss Jones has indicated that she's willing to accept the offer extended by the state. If we can be set for the next available plea docket, that's all we have on Miss Jones this morning.
Is the plea for probation or time?
For probation, Your Honor.
All right, Ms. Jones, what I'm going to do is set you for plea on January 7th at 9 a.m. Mr. Gimbel is going to have a notice of appearance for you to sign. Once you receive the yellow copy, you'll be free to go. Yes. Lori Rush. CR 20193. Ms. Rush is also set for pretrial today. Have you received the discovery in the case, Mr. Gimbel?
Discovery is complete, Your Honor, and if we could be set on the next docket for Miss Rush, we have no pretrial issues.
So you're just wanting a docket call setting for more time to consider any plea offer?
Yes, Your Honor.
All right, Ms. Rush, I'm going to set you also on January 7th for a docket call. And it's on that date I'll expect to hear whether or not you're going to accept the state's plea offer, or there's a counter offer, or you want a trial by the court or a trial by the jury. Yes. Ms. Rush, I'm sorry. Real quick, I need you to report to pretrial release. We have some paperwork for you to sign. Conditions of pretrial release that would be placed on your bond in this case.
Your Honor, that's all my business this morning. May I be excused?
Yes. Do you have anything this afternoon, Mr. Gimbel?
No, I don't, Your Honor.
All right. Thank you, sir. Mr. Pointer, are you ready? Mr.
Sorry?
Guzio? this is CR 20-106-107, State versus Xavier Alexander Busio, and we're set for docket call in each case.
Yes, Your Honor. At this time, we had requested a little bit of time to produce some, I think, very relevant material for the state to consider that may result in a little different plea offer, and we've done that, and I think the state joins in us in asking for one final reset so that they can consider that.
When was the information provided?
This morning, Your Honor.
And how long have you had the information?
I got it about 2 or 3 days ago.
What about your client? How long has your client had the information?
It was, what it is medical evidence tending to explain on a DWI with 0 alcohol why his behavior was abnormal. And it only became, they had some difficulty getting the medical records since it left. So I gave it to him as soon as basically as I could.
State, any response?
Your Honor, we would agree and join. It's not very much, but I am going to need to review that and then re-review the case in light of that to see if that would alter our plea offer in any way. So we would ask for another setting.
All right, the court will set Mr. Busio then for an additional docket call on January 7th. Do you have any scheduling issues on that date?
I think I do, Your Honor. Is the 12th available?
It is.
Okay, I'm free on that date.
All right, court will set Mr. Busio then for January 12th for docket call. Mr. Calabria, don't let me lose sight of you out there. Okay, all right. Mr. Knoll, are you ready?
Answers on several cases. My first is Anthony Davis, Your Honor, at the bottom of second page.
Have you heard from Dawn Davis?
I have not.
She's contacted the court, said she's running late.
Judge, I think she was recently, within the last couple of weeks, released from jail.
That's correct. Yes, once he receives his yellow copy, then yes, you're free to go. Thank you. You're welcome. Anthony Davis, CR 20-111.
Judge, on Mr. Davis's case, we have reached a plea agreement. We have plea papers. We're working on those now. We hope to get that accomplished this morning.
Okay, all right. So, Mr. Davis, just go ahead and have a seat, and I'll recall your case when the paperwork's complete.
Yes, sir.
And I think the court has indicated Don Davis is running late.
Correct. Are you ready on Mason Foshi?
On Mr. Foshi, Your Honor, Mr. Foshi hasn't had the opportunity. I think after the last docket call, I picked up the last of the.
Well, let me bring him up here so he knows what we're discussing. Are you ready on him now? Are you ready to make an
Yeah.
announcement? CR 2247, Mason Foshi. All right, Mr. Foshi set for pre-trial today. Go ahead, Mr. Knowles, what you were saying.
Thank you, Judge. I picked up, I believe, what is the last video. He actually has two cases. One is not indicted. I think I've got all of the discovery on both cases. I'd like to set this for one more pretrial, and we should be able to resolve it then.
He has another felony case.
He has an unindicted case.
Any objection from the state? No.
No, Your Honor.
All right, the court will set Mr. Foshi then for an additional pretrial on January 12th. Mr. Knoll, before you take that back there to him, Mr. Foshi is delinquent in his pretrial supervision fees. He's delinquent $180. So I need you to, Mr. Foshi, I need you to meet with the pretrial release department before you leave to address that. You understand? And do you understand that it's a condition of your bail in this case, a condition of your freedom during the pretrial pendency of this case, that you pay towards your attorney fees and you pay for your supervision? Your failure to do that, with you having the ability to do that, could result in the court revoking your bail back to jail. Do you understand that? And you made good faith efforts to satisfy what you owe and comply with your conditions of pretrial release. Okay?
Yes, sir.
So Mr. Knoll is going to have you sign this form. You're going to get the yellow form, and I want you to come over here and have a seat until pretrial release can speak with you. Yes, sir. I'm going to have Mr. Foshi sit over here. Let me know when we have any information as to what she wants prior. All right, this is Thomas Perry Jr., CR 2267. We are set for pretrial today, Mr. Knoll.
Judge, I believe I have all the discovery in that case. I did receive sometime yesterday, as I recall, two alternative offers as far as plea recommendations. Mr. Perry has not seen the video, has not been by my office. I gave him a business card yet again with my address, the date to be at my office, which is the 15th. That's next Tuesday at 9 a.m. to review his video and anything else he needs to see discovery wise. So if we could just get one more pretrial.
Any objection from the state?
No, Your Honor, that's fine.
All right, court will set one additional pretrial for Mr. Perry on January 12th, 9 a.m. Mr. Perry, once you sign this notice of setting, need you come over here and have a seat. Pretrial release wants to speak with you.
Yes, sir.
Jeremy Powell. CR 20268. Mr. Powell set for pretrial. Mr. Noel, go ahead.
Judge, I believe the discovery is complete. There may be some phone records, but I'll double check that. I sent some information. Actually, I've talked to Mr. Cox and Miss Curry at Mr. Powell's last setting, I believe it was. Or actually, it wasn't Mr. Powell's last setting, but I did talk to Miss Curry. I sent her some additional information. I believe it was yesterday. I have not heard back from her. One more pretrial, and we should be able to resolve the case one way or the other.
Any objection, Mr. Cox?
No, Your Honor.
All right, Mr. Powell set for additional pretrial on January 12th.
And I do have a plea recommendation as of now. We're waiting to hopefully get a little bit better. With that, I'll wait and see when Ms. Davis gets here and
You're free to go, sir. Okay, Ms. Davis gets here, your plea gets ready, let me know. Mr. Claver, Mr. Adams? Wendy Ledoux, CR 20-173-174. Show that Ms. Ledoux is set for docket call today.
Yes, sir, she is. She's present. Good morning. Your Honor, I recently spoke to the state, and I believe by agreement that we'd like to ask the court to reset this case for another docket call. The state and I are in the process of trying to resolve a plea agreement. We believe with some more time, it'll give us that opportunity. I believe the state needs to speak to maybe a witness or a complainant, and my client needs time to facilitate some fundraising. And that's where we are with our plea agreement at this time.
The state with a request for an additional docket call.
Yes, Your Honor, that's correct. I need to sit down and meet, actually, it's probably going to be over Zoom with my victims on this regarding the restitution. Mr. Calabria and I have made significant efforts to resolve this case, and I do believe that it will be resolved, but I do need to run that by the victims. In this case, there's it's a family, but it's two couples, each of them the named victim in each of the two cases. State's going to request at least a 30-day reset to facilitate that discussion with the victims.
Okay, the court will set Ms. Ledoux for docket call on January 12th. Ms. Ledoux, once you sign this notice of appearance, you'll receive the yellow copy, and then you'll be free to go.
Your Honor, is that at 9 a.m.?
9 a.m.
Your Honor, I believe that's all the business I have with the court this morning. You may be excused.
Yes, sir. Good to see
I
you.
don't see you for the holidays. Y'all have a nice Christmas.
Yeah, Merry Christmas. Mr. Adams, you ready? Jake Wilson. All right, he wasn't here when I called his name earlier. I thought maybe he had perhaps gotten here. I do not show any other notification to the court that Mr. Wilson's running late or otherwise indisposed, and he's not appearing in the online courtroom, to my knowledge. So.
We spoke yesterday, Mr. Wilson and I, about this morning and the time to be here. And so I won't represent what Mr. Wilson knows, but I know what I told him. And that was this morning's docket calls at 9 o'clock. I haven't seen or had any other further contact with him. I tried calling him a moment ago and didn't get an answer.
Okay, if Mr. Wilson does appear, do you want the court to notify you to appear via Zoom from your office?
That'll be fine, Your Honor.
Okay, and I believe we're set for pre-trial today, so
That's correct.
if he does appear, I'll have Ms. Abraham or Ms. Barker notify you and allow you to Zoom in.
Very good.
Thank you, sir.
Thank you. I think I've got one more. Mr. Cole. Cole. No mistake. Yeah. I'm not mistaken.
What's the name and I'll look it up for you.
Kobe Shane Cole, COB.
Oh, I believe Mr. Cole retained Mr. Steele. Let's bring them in right now. Kobe Cole. Mr. Steele, can you see and hear the court? Mr. Steele, are you there? Mr. Steele, can you hear me?
Yes, Judge. Good morning.
Good morning. Good morning. All right, and I believe we have.
I have a jacket. I have a jacket and a tie on today, Judge.
Boy, you're doing good this morning.
Thank you.
All right, it looks like your client, Mr. Kobe Cole, is still attempting to connect here. I do have a present in the courtroom with me, Mr. Mitch Adams, the court-appointed counsel for Mr. Cole. And when were you retained on this case, Mr. Steele?
Judge, it was pretty recent. I had his file yesterday. I think I've been on the case about 30 days, maybe. I don't know, Judge. I don't want to tell you something that's not true.
Have you had any contact with Mr. Adams? Did you?
No.
Were you aware of his representation in the case?
I did not. I did not know that, Judge. I apologize.
All right, Mr. Cole, I see that you're connected. Just raise your hand so that I can see that you can hear us. Okay, good. Thank you, Mr. Cole. You can put that down. All right, Mr. Steele, did you file a motion to substitute counsel?
No, I filed a letter of representation, Judge. I don't know. I don't know if my secretary sent over a motion to substitute or not.
Okay, what I'm going to ask then is that you file a motion to sub with an order. Court will grant that. Mr. Adams is going to submit his bill to the court for services provided to Mr. Cole under the appointment of indigent counsel, and Mr. Cole is going to be required to pay that as soon as possible as a condition of his pretrial release. So right now, I show that he's got some delinquencies on his pretrial release, meaning he's not paid. He's delinquent $100 towards his attorney fees for court-appointed counsel and $20 for his supervision fees. So those will need to get taken care of relatively quickly. Otherwise, the court's going to set him for a hearing on his conditions of pretrial release. Any credit that he pays in towards his appointed counsel will go towards the bill that Mr. Adams is going to submit. And I'll have my criminal coordinator send you the amount that Mr. Adams that he bills.
Can he pay that online, or does he have to go to the district clerk's office, or?
He'll pay that through his pretrial supervision officer with the Van Zandt County Community Supervision Corrections Department, whether they take online payments or over the phone payments. He can't pay online, he can't pay over the phone.
Yes, Judge.
Okay. All right.
Hey,
So, well, let me do this. So, Mr. Adams, I'm going to go ahead and relieve you of representation at this time, since Mr. Steele is here making an appearance before the court, and as an officer of the court tells me that he's going to file a motion to sub.
Thank you, Judge.
So if you'll just submit that bill to us, and go ahead, Mr. Steele. I think we're set for pre-trial today. Have you contacted the Van Zandt County DA's office and gotten discovery in this case?
Judge, I know I was in front of you on Tuesday. I do have access to your portal. I had access. I've got 4 cases right now. There may be more cases, but I've got 4 cases that are actually filed and indicted in Van Zandt County. 3 of the defendants I have discovery on the portal. Mr. Cole, we checked yesterday, and I did not have Cole on the portal yet. And I did have just one question, Judge, about the motion substitute. Could I ask you?
Yes.
When I got on this case, I don't think the case had been indicted, and we didn't have any information on the case or a case number. In that case, when the case isn't indicted, do we need to call the clerk's office and see who the court-appointed counsel is, or how do I go about figuring out who his court-appointed counsel is on a case that hasn't been yet indicted, I guess?
Well, I would assume that your client would know, since that was provided to him.
Okay, I'll ask my client in the future.
Your Honor, for the record, Mr. Cole was indicted August 28 of this year.
August 28.
Correct.
Yes, I was just looking that up.
Oh.
So he was indicted on August 28th. He signed his conditions of pretrial release in September.
In fact, we had a pretrial hearing in October for Mr. Cole, where the court granted a motion for independent testing.
So he's already made an appearance with his court-appointed counsel.
I think there's 2 more cases coming, Judge. Maybe I can talk to the DA's office about this, but and maybe court-appointed counsel could let me know that. Are there 2 more cases coming?
It's news to me.
Okay. All right.
Well, we are set today for a status hearing. Do you know what the status was set for today, Mr. Adams?
Your Honor, just as I mentioned in October, I had before the court a motion for independent for a retesting of the alleged narcotics. The court provisionally granted that with the stipulation that Mr. Cole pay the freight for that testing, and I had done the legwork to find out where to send that. There's a lab in Dallas for that. I found visited with those folks to make sure that the testing procedures there would cover what we required of it or wanted from it. I found out how much that was going to cost. Mr. Cole, I think, knew that. We were coming back today to check on the status of the progress of retesting those narcotics. And I never received any, having never received the funds from Mr. Cole to pay that, the retesting hasn't been done.
So the payment was a condition?
That's correct, Your Honor.
Of the retesting?
That's correct.
And has the alleged substance been provided to, is that what you're saying today's hearing was about, to see if
the lab doesn't have it because I never received the funds for the testing from Mr. Cole and never knew that he had paid that cost to the lab for the testing for them to acquire the substance from the law enforcement agency.
So what we'll do at this time then is we will just table that motion for retesting, and we'll carry that forward. And Mr. Steele, if you want to continue arguing that in your representation of Mr. Cole, you may do so. Mr. Adams has given us that information that we need to know regarding the payment or non-payment of the retesting of the substance. So what I'll do is I'll reset this case for a pretrial to allow you, Mr. Steele, to get up to speed. We're going to set this on January 12th. When did I set you the other day, Mr. Steele? Did I give you?
Yeah, Judge, I had that written down. Give me 1 second. I can tell you the answer to that.
I just don't want to book you on 2 different days. While he's looking, Mr. Adams, do you recall off the top of your head what the cost was going to be for the retesting?
It was in the neighborhood of $500, something of that.
And that was communicated to Mr. Cole?
I believe so, Your Honor.
Judge, the case.
Yes, go ahead.
Yeah, the case was January 7th.
Okay. So we'll set Mr. Cole then for January 7th also for pretrial. And any contested pretrial motions need to be filed 7 days prior to that hearing, Mr. Steele, and notice provided to the state.
Yes, sir.
All right, Mr. Cole, you're ordered to be here on January 7th, 2021 at 9 a.m. Raise your hand if you understand. All right, record will reflect that Mr. Cole is appearing online via Zoom and has raised his hand acknowledging the court's order. All right, and so Mr. Adams, if you'll submit your bill, the court will get that reviewed and signed, and we'll provide notice to Mr. Steele and Mr. Cole as to that billing, and then Mr. Steele, I'm going to ask that your client have that resolved and paid for before the next setting.
Thank you, Judge.
Thank you, Your Honor.
Anything else, Mr. Steele?
No, Your Honor. I guess I need to know what DA is assigned to this case over there, but I can call the DA's office to
Okay.
get it out.
All right, so we'll be adjourned in this matter. Thank you very much.
All right, thank you, Judge.
Your Honor, that's all the business I have before the court. May I be excused?
Yes, sir, you may.
All right, thanks.
Mr. Dahl, any of your other clients that are present in the courtroom ready?
See Miss Davis, yes, and Mr. Davis is
Mr. Lloyd, are you ready?
Yes, sir.
All right. This is CR 2080, State versus Clifton Groves. Mr. Groves, if you'll make your way to the middle podium. Mr. Gross is set for arraignment today. Mr. Lloyd, have you had an opportunity to review the indictment with your client?
I have, Your Honor. In fact, I will inform the court that, and we waive the formal reading of the indictment and enter a plea of not guilty for purposes of arraignment. I understand that has already been provided to the court as well. I would additionally inform the court that late last evening, I was finally able to get, I believe, the majority of the discovery, and we will be able, obviously my client's not been able to review that because I wasn't able to get all of it. Additionally, I'll inform the court I had talked to Ms. Curry about this case a couple of times. However, I have some information, including some videos that I have indicated that I was going to provide to the state. Irrespective, I would ask the court if it would consider passing this until a January docket where I hope to be able to get everything resolved, and we'll be ready to move forward. I noticed in the discovery that I believe another prosecutor, Ms. Heisel, may have actually been the attorney on the case. I've not spoken to her, and I believe looking through that, it seems that there may have even been an offer there, which I've not even within the body of the portal. I don't know if that was a message or I suspect some sort of recommendation, Judge.
All right, thank you. That's fine. So the court will enter Mr. Gross's plea of not guilty into the record, and we will set this for a pretrial hearing on January 12th. Do you have any scheduling conflicts on that date, Mr. Lloyd?
No, I don't believe so, Judge.
All right, and so the court will require, pursuant to the statute, that all contested pretrial motions and any other pretrial motions be filed 7 days prior to January 12th. And so, Mr. Lloyd, what I'll be looking for on the 12th is if there's any issues with discovery, you'll let me know. Other than that, I'll be looking for some type of announcement on whether or not you're going to be requesting a contested pretrial motion hearing, motion to quash, motion to suppress, things of that nature. And if there are none, then we'll have a docket call setting after that.
Thank you, Your Honor. I appreciate that.
Now, my bailiff is having Mr. Gross sign the notice of appearance, and we're going to give him a copy of that. The only other issue that we have with Mr. Gross right now is I showed that there is a bond forfeiture warrant issued for him for failing to appear to court at the previous setting. That was back in that was back in October. I believe Mr. Gross was on a personal bond,
He
and,
may,
and he
yes,
failed
sir.
to appear on October 20th. So the court called his name 3 times in the courthouse, no response, and issued a warrant, and that's active today. And I wanted to give the state and you, Mr. Lloyd, a chance if y'all have any recommendations to the court on that. I mean, he's here today. He has counsel, and it was a personal bond.
Yes, Your Honor. I would just inform the court that my client had been incarcerated in Smith County for some time, and I'm unsure as to whether or not he had been released as of that date. So I can double check that, but I'm almost positive that he was in jail. I had been in touch with Miss Curry several times, and we were working toward getting him released. He had evidently a bond issues over there, and I'm not sure of the date, but he certainly can tell you, but he was placed on probation and released shortly thereafter out of Smith County. So that's all I would ask the courts to take that into consideration, certainly. And I believe that the state was aware of that as well. At least I know when I talked to Miss Curry the first times, a couple of times, he was incarcerated during that time as well.
What I'm gonna go ahead, Ms. Heisel.
I was just going to say that's correct, Your Honor. We were aware that Mr. Gross had been in the Smith County Jail for a long time in several of his settings. We did confirm. I don't know that last setting, whether it was confirmed or not. Obviously, if he was in custody in another jurisdiction, then we, would not hold that against him. Would ask the court to dismiss that. However, if we can confirm that he had already been released, then we would ask to go forward with the NISI and take him into custody.
Gross, raise your right hand and place you under oath. Sir, do you swear that the testimony you give today to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can put your hand down. And Mr. Gross, I'm going to ask you a very specific question, and I don't want you to divulge any information other than what I'm asking. Okay? Because any information that you say perhaps could be used against you in your prosecution for this case or for any future case, maybe related to failure to appear, bail jumping. You understand?
Yes, sir.
Okay. The court previously had you set for arraignment on October 20th of this year, and you did not appear on that date, and the court issued a warrant for your arrest. Were you in custody on October 20th of 2020?
I believe so, sir.
Do you know
I remember receiving a waiver of arraignment while I was incarcerated in Smith County that I think had an October 9th and an October 20th date. I don't think I was released until November sometime.
That was going to be my next question. Do you know exactly when you were released?
No, sir. I have all the information on my phone.
Do you have your phone with you?
Yes, sir.
Go ahead and access your phone.
Judge, I will inform the court that I had provided him some dates on his waiver of arraignment that I do not believe we were able to get accomplished. I'm just, again, it's his testimony. I'm unsure, but I know I provided him a waiver of arraignment on a couple of occasions. Once it didn't even have a date on it because I was unsure.
And Judge, while he's looking that up, could you remind the state's, refresh the state's recollection about the date of the failure to appear?
Yes, ma'am.
The
clerk's record reflects that arraignment was set on October 20th. And it was previously set July 9th, August 25th, and October 20th.
Your Honor,
Yes, sir.
am I allowed to call Smith County because I can't find it on their website? And when I needed to receive a release date for Van Zandt County, I had called the jailhouse and asked when I was released.
Judge, I have it if Mr. Gross is not able to access it.
Go ahead, Ms. Heisel.
Your Honor, according to the Smith County booking website, Mr. Gross was in the Smith County Jail from April the 24th of this year to October the 7th of this year.
All right, Mr. Gross, this is what we're going to do. Okay. There is a warrant out for your arrest, and that is for missing court on October 20th. The information before the court is that you were out of custody at that time. So the court should take you into custody today for missing court. What I'm going to do is I'm going to withdraw the judgment nisi in the warrant. Since you made an appearance here today, you're here with your counsel, and your counsel's indicated that he has been working on your case with the DA's office. I'm going to withdraw that, and we're going to set your case on January 12th, as we already have. All right, I'm going to allow you to leave today, and you're ordered to be back on the 12th. If you're not back on that date, the court's going to issue a warrant. Again, we'll issue a warrant for your arrest, and that one will not be withdrawn. Understand?
Yes, sir.
So as you leave today, that warrant's going to be active. That means you need to be careful until the paperwork can be processed to withdraw that warrant. It means if there's a traffic stop, or you go in to get your license renewed, or there's contact with law enforcement, and they run your name within the next 24 to 48 hours, they're probably going to take you into custody on this warrant. You understand? So I'm going to, once I get through with my settings today, I'm going to start the paperwork to withdraw that warrant. Okay? But it's going to be active for a little while. Do you understand what I'm telling you?
Yes, sir.
And if you don't, tell me you don't.
No, I just wanted to state one thing. I had received a waiver of arraignment from my attorney, and I was supposed to sign that and turn it into the district clerk, which I had did, and she said she was going to contact the judge over the case.
And that did happen. The problem was that there was an error with that. There was no acknowledgement of your next setting, so the court rejected the waiver. So I know that, and I'm taking that into consideration at this time, that the October 20th date should have been waived. If you would have had that date and your acknowledgement of not guilty put into that waiver, then you wouldn't have missed court. So I'm taking that into consideration. So I'm saying I'm going to let you go. Be cautious for the next 24 to 48 hours so that I can process the paperwork to withdraw the warrant and get it out of the system.
Yes, sir.
So you're going to be free to go, and we'll see you back on January 12th. But just know that for the next 24 to 48 hours, the warrant could be active.
Thank you, Your Honor. And my apologies to the court. I guess I was unsure as to when I was going to be able to get him before the judge over in Smith County to I guess solidify the dates that he was supposed to appear there, and that's on me, Judge. I apologize for that, and I appreciate the court taking that into consideration.
Well, you're welcome, and but I do acknowledge that there was an attempt at a waiver of arraignment. It just was not done completely, correctly. But that Mr. Gross did sign that with counsel, but it was rejected by the court, and that was
Thank you.
That was in October. So I'm going to give him the benefit of the doubt, and we're going to give him a pass on that one, and hopefully we'll move forward, and that won't be an issue again.
We will. Thank you, Judge.
All right, so we'll see you back on January 12th.
Thank you, Your Honor. May I be excused?
Yes, sir.
questions on, Mr. Lassiter? If we can real quick.
Jonathan Lassiter, if you'll come to the middle podium, please, sir. CR 20258. Mr. Lassiter today has requested a court-appointed attorney. The court has reviewed his request, found him to be indigent, has appointed the Honorable Kurt Knoll to represent Mr. Lassiter. Mr. Lassiter is charged with driving while intoxicated, third or more offense, and we were set for arraignment today. Mr. Knoll, can we go ahead and arraign Mr. Lassiter today?
We can, Your Honor. He and I have reviewed the indictment. I was given a copy of the indictment. His name is spelled correctly, and for the purposes of arraignment, we can enter a plea of not guilty if the court would allow.
Court will enter Mr. Lassiter's plea of not guilty into the record, and we will set Mr. Lassiter then for retrial in this case on January 12th. Mr. Lassiter, as Mr. Knowles filling out that paperwork, have you been provided with your copy of your conditions of pretrial release? Okay, so you've read over those and you understand that you're required to report, required to pay towards your attorney fees, and required to pay a supervision fee. You understand that? That if you fail to do those things, the court could find your bond insufficient and put you back in jail. You understand that? Questions about those terms? You're free to go, Mr. Lassiter. Anybody else? Mr. Knoll at this time?
Miss Davis Dawn Davis is now present.
Okay, I'll call her in just a moment. I'm gonna step off the bench for like 2 minutes. 2 minutes, Mr. Stevens. I'll be right back. Mr. Davis. You'll come to the center podium. All right, this is CR 20-111. State versus Anthony Michael Davis. You are Anthony Michael Davis, correct?
Yes, sir.
Sir, raise your right hand. I'm going to place you on oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, put your hand down. Mr. Davis, are you a United States citizen?
Yes, sir, I am.
Do you read, write, and speak English?
Yes, sir, I do.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Kurt Knoll. Are you pleased with his representation of you?
Yes, sir, I am.
You feel like you've had sufficient time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've reviewed and signed that you do not understand?
No, sir.
Mr. Knoll, do you believe your client to be competent today?
I believe he is, Your Honor.
And you've explained to him his legal and constitutional rights, and also have you explained to him the benefits and also the disadvantages of a deferred adjudication plea?
I have, Your Honor.
Mr. Davis, you're charged by indictment with a state jail felony offense of abandoning or endangering a child with criminal negligence. That carries a range of punishment of not less than 6 months or more than 2 years confinement from the Texas Department of Criminal Justice Institutional Division, and a fine not to exceed $10,000. That means any sentence ever handed down in this case by the court or by way of plea agreement must fall within that 6 months to 2 years. You understand that?
Yes, sir, I do.
Now, it appears to me that there's a plea agreement between you and the state in which you would plead guilty to this offense, and the state recommends that the court defer a finding of guilt and place you on community supervision for a period of 3 years with a $2,500 fine, $290 court costs, $590 reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir, it is.
And that's what you're asking the court to approve today?
Yes, sir.
Mr. Davis, then at this time, how do you plead to that offense?
Guilty.
Are you pleading guilty because, in fact, you are guilty?
Yes, sir.
And for no other reason?
No, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to this charge?
No, sir.
The court will accept Mr. Davis's plea of guilt. And Mr. Knoll, is there any objection to States 1, the stipulation of evidence?
No, Your Honor.
All right, court admits States Exhibit 1 and takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Yes, Your Honor, just briefly. This does arise out of a case that's working in conjunction with the CPS case. And so I just wanted to update the court that Mr. Davis has been successful in working his plan for CPS. He has been successful on his urinalysis and hair follicle test with CPS for the past pretty good stretch of time, and that is the reason for the state's plea offer in this case, just to give Mr. Davis an opportunity to continue to be successful while working that plan and also on probation.
Thank you, Ms. Hodges.
Just also to follow up with Ms. Heisel's, he did complete a program at Senecor also. I think that was probably part of the CPS work. So he's headed in the right direction.
That's great news. All right. Let me review the stipulation here. Is there anything further from the defense?
No, Your Honor.
All right, then based upon the court's review of the evidence, the court finds that there is sufficient evidence to support this plea and to convict Mr. Davis. However, the court will defer a finding of guilt in this case in conjunction with the plea agreement. The court hereby places Mr. Davis on 3 years deferred community supervision. Court assesses a fine of $2,500, court costs of $290, and orders reimbursement fees in the amount of $590. All right, Mr. Davis, I'm pleased to hear the report from the DA's office about your progress with CPS. I'm pleased to hear the information from Mr. Knoll about the Senate Court. I'm pleased to hear all of those things. However, in reading the offense report, I'm quite concerned about the kids, right? Quite concerned about that. So obviously, it's our job as adults to protect children from things that are harmful to them and that they don't have a choice in doing. And I know that you understand that.
Yes, sir.
Or hope that you understand that.
I do.
So I hope that you're on the road to recovery and that you have realized the error of your ways. What we're going to do is we're going to have you on probation, and the probation department is going to tell me if you violate any of these things, and if there's even the hint of methamphetamine or any kind of endangering a child due to methamphetamine or anything else, we're going to come back in here, and this is going to be a lot different between me and you. You understand?
Yes, sir, I do.
So today is your opportunity. The state's giving you an opportunity to prove yourself, prove your worth in doing and upholding your word. All right. So
yes, sir.
Well, we're going to uphold our end. Now it's up to you to uphold your end. If you let that down, then and you put me in a position to do my job, I'm going to do it. And you know that range of punishment is 6 months to 2 years. All right. So that's what's hanging over your head. So I hope that's a strong incentive to continue the positive recovery for whatever addiction you may have. You understand?
Yes, sir.
Okay. Mr. Davis, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of the sentence. I'm going to have you step forward here to be fingerprinted with my bailiff. After that, Mr. Davis, I want you to report to the probation department over here through this door.
Yes, sir.
Dawn Davis, CR 20112. All right, Ms. Davis is set for pre-trial today on her possession of controlled substance. Go ahead, Mr. Knoll.
Judge, I do have all the discovery. Miss Davis was released, I think, less than a month ago. We've not had the opportunity to review all of that discovery. One more reset, and I think we'd be ready.
Any objection from the state?
No, Your Honor.
And I'm not sure if there was an actual plea offer made on this case yet or not. I think this may be Mr. Cox's case. I'm not sure.
I'm checking right now to see if I've made an offer. If I haven't, I'll get one to Mr. Knoll by the end of the day.
All right, Ms. Davis, you're set then for pre-trial to be back before the court on January 12th at 9 a.m. Ms. Davis, you also still have the capious profiling that's not been resolved. Have you been able to access your funds to satisfy that?
I haven't been able to access my funds, but I did bring $100 to pay on it today, but they told me to come and do this first.
Okay, good. Yes, if you'll do that, I'd appreciate it. And if it takes $100 a month, then that's fine. Let's just get it resolved.
Okay, thank you.
Also today, Ms. Davis, before you leave, I'm going to need you to meet with pre-trial release. Sign this paperwork. Good. So they've already started that? Okay,
yes,
make
sir.
Make sure you sign that paperwork, and once they tell you you're free to go, then you're good to go.
Okay, thank you.
Judge, I checked my records. I made an offer to Mr. Knoll back in November.
Is it in the portal?
It should be, but I'll send Mr. Knoll an email just in case.
Thank you, Mr. Cox. Did you hear that, Mr. Knoll?
Yes, I think that was for lack of a better way of phrasing it, in passing offer. I think we were in court last time with Miss Davis. But
Mr. Stevens, are you ready?
yes, sir.
Leslie Gibson, CR 20249.
Judge, that's all I have till this afternoon.
Thank you, Mr. Knoll.
Thank you.
Ms. Gibson is set for pre-trial today.
Yes, sir.
Go ahead.
Judge, I'm going to ask for another pretrial setting. The reason being, I was appointed in court last time on the last setting. I've seen the discovery in the portal, but I believe there might be a video that I don't have yet. So I would respectfully ask for another pretrial setting if you.
I think I've given out all the resets today.
Oh, well. That'd be my luck, Judge.
Any objection from the state?
No, Your Honor, and we will make sure that video is prepared if it's not already.
Thank you.
Mr. Stevens, are you available on the 12th?
Judge, I have a mediation on a CPS case. My client's incarcerated in Kaufman. They haven't told a time if it's going to be at 9 or 1:30. I hate to commit and then I turn around and have to call you back.
What about the 7th?
The 7th. I think I'm in here on the 7th at 1:30.
Jail docket.
Oh, yeah, that would be jail docket. I think the 7th would work a lot better than the 12th, Your Honor.
All right, let's set up for the 7th then.
All right, sir. Will that be 9 o'clock?
That'd be 9 a.m. You said you're here at 1:30 that day?
Yes, sir, 1:30.
You want to set this at 11?
That would be very helpful. Yes, sir. I'd love that.
Let's just set this one at 11.
Okay, sir.
We'll accommodate your schedule a bit.
Be great.
Judge, just for the record, Miss Abney said that Mr. Stevens picked up Miss Gibson's videos on the 30th of November when he picked up the rest of his discovery.
That's nice to know. I'll find it, Judge. I'm sure it's at the office.
All right, so we'll see you back on January 7th, and it'll be at 11 a.m., Ms. Gibson, okay? You can get here at 9 and sit if you want. Otherwise, you're not required to be here till 11.
May she be excused, Your Honor.
Yes, we'll see you back at 11 a.m. on the 7th.
And may I be excused, Judge?
Yes, sir.
Thank you, Judge. Sorry I was late. I got Brad to cover me in Henderson County, and then I made a quick call from an appearance.
Been all over this morning.
One of those days, Judge.
One of those days.
Yeah, thank you, Judge.
You're very welcome. Jeffrey Furr. All right, Mr. Furr, this is cause number CR 27A. You've been indicted with the state jail felony offense of theft. And we're set for arraignment today. Are you hiring an attorney to represent you?
Yes, sir. I'm trying to get the money together right now. I'm planning on hiring one.
Who are you trying to hire?
I'm not real positive yet. I just talked to a friend of mine this morning, actually. for him to help me get the money to go ahead and hire one. I wasn't sure if I was going to not have to get a court appointed there for a minute, but I did talk to somebody earlier, and I'm going to be able to go ahead and hire one, I believe. I haven't got to check with see who all is even here to even, look at.
All right, Mr. Furr, this is your first setting on arraignment. The court's going to reset your case until January 12th for arraignment to give you time to hire an attorney. So when you come back on January 12th, I expect you to have a lawyer with you. Okay?
Yes, sir.
All right, we'll see you back on January 12th, 9 a.m. Is Christopher Mata here? Mr. Zarate? CR 2278. Mr. Zarate, I show that we're back here today on a status for you to hire an attorney, meaning that the last time you were here, I reset your case for you to hire an attorney. Did you hire an attorney?
No, sir. I was talking to Ron Wells, and he appointed me, or he referred
Hang on,
me to.
I can't understand. You said it again. You were talking to who?
Yes, sir. I was talking to Ron Wells, and he told me to gather some money, and I did, like 2 weeks, 3 weeks after, and then he referred me to Nolan White. So I had an appointment to meet with him yesterday, but for personal reasons, he rescheduled me for today, if possible.
What time today?
I was gonna call him after the court.
So you don't have an appointment with him today?
Yes, sir. I do. I was gonna call him to see the actual time.
So you could have already missed it.
Sir?
You could have already missed the appointment then. You don't know what time the appointment is today?
No, sir. I was gonna call him after the court. Or I think he did tell me to call him after the court, because I went to go to his office yesterday, but he rescheduled me.
All right, Mr. Zarate, I'm going to order you to be back before the court next week on December 17th at 9 a.m. And I expect you to have Mr. White or someone else retained on that day.
Sir. December 17th. Yes, ma'am.
All right, we'll see you back next week.
Yes, sir.
Mr. Zarate. Mr. Zarate, before you go, I think our pretrial release department needs to meet with you.
Yes, sir.
So just come over here and have a seat, and they're going to have some paperwork for you, okay? After they're done with you, you'll be free to go.
Yes.
Your name, sir? Oh, yes, Mr. Mata. I thought I called you just a moment ago. I called you at 9 a.m. You weren't here. Come on up. This is CR 2261, State versus Christopher Gene Mata. Mr. Mata, I show that I rescheduled your previous hearing for you to hire an attorney. Did
Yes,
you hire
sir.
one?
Yes, they're trying to charge me $5,000, and they won't see my case or do nothing with it until I give them half. And my unemployment's only $800 every 2 weeks, so I don't have enough money with my bills and all that. I won't have $2,000 for a couple months to get them started.
Try to hire different attorneys that charge different amounts.
The cheapest one I found was $4,000, and all the ones in Terrell, they won't come out here to Van Zandt County.
You ever thought about calling an attorney in Van Zandt County?
I called one, and they told me $5,000, and they said I had to have $2,000 to come up with.
So you called one attorney here.
Yeah, one attorney here in Van Zandt, and the rest were in Terrell and some that I found online, and it just all of them keep telling me the same thing: $4,000, $5,000. And with my unemployment, I don't know how I'm going to be able to do it. I've been laid off since April.
Well, you do understand that I can't just keep resetting your case over and over and over.
Yeah, I know that, sir.
Your spouse still working?
Yes, she's still working. She makes about the same thing as I do. Just, I was a welder. I worked in West Point before I got laid off, and I was making good money. And just, I don't have another job lined up until January. They told me to come in January and check right there in Terrell. I'm a welder by trade.
Mr. Mata, I'm going to do for you what I did for Mr. Zarate. I'm going to give you one more week, all right? Because this is our third time to be here. I'm sorry, this is our second time to be here. So I'm going to set you one more time. I'm going to set you for next week, okay? That means you're going to have to get on the phone. You're going to have to call more than just one lawyer. And you're going to have to try to figure out how to work out a payment plan or do something.
Yeah, everyone that asked about the payment plan, they kept telling me I have to come up at least half. And
I understand. I want you to come back on Thursday, and I want you to, if you do not have a lawyer with you on Thursday, then I expect you to give me detailed information about who you talk to, when you talk to them, how much money they want, and how much money you got.
Okay.
On at least 5 attorneys.
Okay.
5 attorneys. I think that's fair.
Okay.
Okay. So next Thursday at 9 a.m.
Your Honor, just confirming that's December 17th.
December 17th. Yes, ma'am. I'm sorry. Attorneys?
5.
5. Who you talk to, when you talk to them, how much they charge. I don't want to hear I talk to some guy, I talk to some girl, I can't remember her name. I'm talking about, I need names, I need dates, I need what y'all talked about, how much money you've got saved, how much money you can pay, and what they're charging.
Okay.
Okay?
All right.
Any questions?
No, sir.
All right, see you back next Thursday.
Thank you.
State, I don't see anyone else on the docket that we have not called. Show that we have two people that did not, or at least one person that did not appear. That was Jake Wilson. You see anyone else on your docket, State?
Judge Jake Wilson's the only person I have.
Okay. And Mr. Hyde has contacted the court. Has he been in contact with you all about his plans this afternoon?
About Mr. Martinez testing positive, Your Honor.
Yes, but Mr. Martinez testing positive, and then he asked if I still wanted him to come over and plea out Mr. Salazar, and I told him yes.
Okay.
So
That's our plan as well, Judge.
I asked him to be here, so you're aware of that, okay? And then I have that Mr. Manning's going to be a little bit late this afternoon. Mr. Knowles is here, so okay. All right, if there's nothing further, then we'll be adjourned until 1:30.
Thank you, Judge.
Oh, I'm sorry. State, hang on just a second. I forgot about Mr. Schmidt's call. Mr. Crawford, will you come around here so the state can see you and hear you better? This is Mr. Mercer, right?
Yes, sir.
All right. Yes, the court had Mr. Mercer UA'd because the court had records that he had not reported since last April. And Mr. Crawford, did the department administer a UA test to Mr. Mercer?
Yes, sir, we did.
And what were the results of that?
Showed positive for amphetamine. He's claiming his medication is known to cause a false positive. So we're sending it to the lab for analysis and confirmation.
And we anticipate about how long for that to come back, a week or so?
2, 3 at the most.
All right. Mr. Mercer, come on, step on over here at this podium. Your attorney's not here anymore. He left. Otherwise, I would inform him. You're already set for January 12th. I'm going to let you go today. All right, we're going to be back on the 12th. The lab is going to confirm whether or not your medication is going to be the reason for your positive.
See
That's okay. I don't want to hear anything. Okay, your attorney's not here. It's best that you don't say anything. So we're going to come back on the 12th. You've been ordered to report each month as directed, and I show that you haven't reported since April. That's why you UA'd you today.
Well, see, when I came here, that was when the coronavirus just started, and they just had me sign papers and tell me to go, and I didn't even get to sit there and read what all I was signing, and nobody really told me too much about it. I had to report or pay any fines or nothing.
Okay. Well,
What about using meth?
let me do that for you, Mr. Mercer. The conditions of pretrial release, you were given a copy of them. You had plenty of time to read them. And on there, they tell you that you have to report, that you have to pay, that you have to abstain from alcohol and drugs and illegal substances, harmful substances. It says all those things, right? We're going to come back on the 12th, and we're going to take up this issue of your analysis positive for amphetamine. I would suggest that you speak with your attorney and you remedy any of these issues. I show you're delinquent in your supervision fees. I show that you're delinquent in your legal attorney fees that the counties have to pay for your attorney. You need to get with your attorney and you need to get these issues resolved. Okay. We're going to come back on the 12th and we're going to have a hearing about this amphetamine. If I find that you were using, the court's going to, we'll talk about it on that day. Understand?
Yes, sir.
All right. So you got your notice?
Yes, sir.
All right. We'll see you back on the 12th.
All right, thank you.
All right, Mr. Crawford, once that comes back from the lab, you'll notify the court.
Yes.
Thank you, sir. Thank you. All right, State, I think that wraps us up.